Everyone to the Module 4 live session for the contracts course. Our topic this week is statute of frauds and fixing drafting errors. We will be talking about the Module 4 written assignment and the requirements for that memo. We will be going over your Module 4 discussion forum. That first post was due Tuesday. The reply post is due Saturday. You do have a quiz again this week, and you need to submit the correct answer to the live session question by by Sunday, July 31st. So this is a busy week in the course again. Let's get started. So this week we're talking about contracts that actually do have to be in writing. The purpose of that is to avoid fraud. So it's called the statute of frauds. It requires that 6 types of contracts be in writing. You can remember these 6 types of contracts using the acronym MyLegs. Contracts for marriage, contracts that cannot be performed within a year, contracts for the sale of land, executor contracts, contracts for the sale of goods greater than $500, surety, ship, and guarantor contracts. So the statute of frauds has been incorporated into the Uniform Commercial Code, into the UCC, and the statute of frauds exists in common law. So it would apply to contracts for services also if they cannot be performed within a year. And many states have their own version of the statute of frauds, and it's been codified and put in their statutes. Let's talk about your Module 4 memo. So your assignment this week involves a scenario in which Jill and Will are independent contractors. They've completed technology products for people and businesses, but they've never sold parts because they did not want to collect sales tax or deal with the paperwork. In the past, their carefully selected customers have been great. Collection of bills has not been difficult, and they preferred not to use written bids or contracts. However, Will and Jill have now changed their mind due to customer needs. They have sought advice from your law firm and your supervising attorney. They've decided that they will sell bigger ticket items, and these goods would fall within the statute of frauds. So Jill and Will understand from their research, if they have a contract over $500, it must be in writing to satisfy the UCC's version of the statute of frauds. However, they would like a research memo done. And this happens all the time. Clients will walk into your supervising attorney's law firm and ask for a research memo and to have done for their business purposes so that they can keep it on file. So our clients, Jill and Will, want more accurate information. So the supervising attorney wants you to do a survey of recent cases and articles on the statute of frauds so that she has up-to-date basis for legal advice. Okay, let's take a look at the questions. So the first thing you need is a recent case in Lexis or Fast Case, a recent article in the Rasmussen Online Library. These should both be about the statute of frauds, a legal blog that you could find on Google about the statute of frauds. Fourth, a statute of frauds or a statute requiring a writing that has been enacted in your home state. So again, you can search Fast Case, you can search Lexis Advance in your home state and find the statute of frauds. Or in the appellate case, you need to do an IRAC, issue rule analysis conclusion. Use Blue Book citations for every source. I'm going to share my desktop with you so that we can take a look at how to do this assignment. Everyone okay with that? I'm going to do part 1 of the assignment and find a recent case in the statute of frauds. So
I have a quick.
Go ahead.
So we have to do IRAC for all 4 of them?
No.
Okay.
How would you IRAC a legal blog? You wouldn't. So let me read part 5. Additionally, for the appellate case, complete and include an IRAC analysis. So it's only for the case. When you have a case, you need to identify the issue, the rule that the court cited, the analysis, and the conclusion. So that's for part 1 only. Part 2, summarize in a short paragraph. Part 3, summarize in a short paragraph. Part 4, cite to the statute of frauds in your state. Does that make sense?
It does.
Let me start by doing part 1 of the assignment. I'm going to go into fast case. Let me share my my screen, share my desktop with you. Go back into the classroom. If I can. There we go. So I want to access fast case. One way to get to that is to go to the Justice Studies homepage. You should become familiar with this. You should save it as a favorite. You should be bookmarking it. Add this page to your favorites. Everyone see this Rasmussen Online Library website? Going under Paralegal. And there's fast case. I'm going to search for the appropriate case. All right. It's asking for a statute of frauds case. We're going to assume that I live in Minnesota. So there it is. I'm looking in Minnesota, and I want to find a recent case. Statute of frauds, written contract. I got 662 hits. I'm going to try this very first one because it's from 2022. Vermilion State Bank versus Tennis Sanitation Limited Liability Company, decided by the Supreme Court of Minnesota on February 2nd, 2022. Here's a summary. The Supreme Court affirmed the judgment of the Court of Appeals, concluding that the limited liability company breached the contract between the parties, and as a result of the breach, the bank suffered almost $2 million in damages. So we want to see what the what this case says about the statute of frauds. Here we go. Tennis made a post-trial motion for judgment as a matter of law, saying there was insufficient evidence to prove the existence of a contract, and it was unenforceable under the Uniform Commercial Code statute of frauds because this contract was not in writing. We have Nicole joining us. Hi, Nicole.
How are you?
Fine.
Okay, I'm here.
Can everyone see the case that I was looking at?
Yes.
Awesome. On appeal to our court, the limited liability company argues that the trial court committed errors and it's ruling because the UCC governs the contract for the sale of goods, and the UCC statute of frauds renders the oral agreement unenforceable. So this is a good case. This case right here will work for part 1 of the assignment. So what I've done, Nicole, is I just did part 1 of the written assignment. I went to fast case and I found a recent case in the state of Minnesota on the statute of frauds. Any
Okay,
questions?
I'm writing it down. So I'll know where I'm at, what to do to go
Awesome,
back.
so-
And that was part 1 of the assignment, correct?
Yes.
Okay, perfect. Thank you so much.
So what I want to do, hello, everyone still here?
Yes.
Excellent. Let me bring that PowerPoint slide back up. We can go on with Module 4 assignment. Okay, so the assignment says find a recent case in Lexis or fast case. The next is find a recent article in Rasmussen's online library. All right, let me do that part of the assignment for you as well. I'm going to go back to sharing my desktop. Find a recent article in the Rasmussen online library on the statute of frauds. Sharing my desktop. All righty. Go into Rasmussen's online library. That's under course and institution tools, library resources. Here we go. Search the online library for statute of frauds contracts. Institutional error. Search for ebooks. It says find an article, right, in the Rasmussen library.
Yes.
All right, all resource types. We were unable to validate. Please try again. Institutional login. Let's me be patient with the technology and try to log in. Sign in problem. Okay, and what was the third one? Find a law blog on the statute of frauds.
Yes.
You'll have to do the second one on your own because it would not let me log in due to some technical difficulties. So I'm going to part 3. I'm looking for a law blog on the statute of frauds. Here's one. Looks like this guy, Weisblatt, is his law firm. Don't need to talk to anybody. We just need a blog. And here's one, statute of frauds in business contracts. A highly important part of business is entering into contracts with other businesses, whether you're providing or receiving the goods or services. It's essential to ensure that your contract meets all necessary legal requirements to be enforceable. One requirement that may exist under certain circumstances is that the contract be in a writing. Let me skip to this third paragraph. A law referred to the statute of frauds requires that contracts with certain terms always be in writing to be enforceable. Texas has its own version of the statute of frauds in the state business and commercial code. And there's the Texas statute of frauds. So if you needed to cite to the Texas statute of frauds, I think that's part 4 of the assignment. There it is. There's the Texas statute of frauds. So here's so you could use this blog right here for part 3. Prepared by attorney Andrew Weisblatt. And he is cited, he's not only provided a blog, he's also given you the Texas version of the statute of frauds. Any questions?
Quick question, and we can use that blog that you just showed for for the section 3 of the assignment. It doesn't
Yep.
have to be like your state, but we could just use that one.
You can use that one right there. You
Perfect.
can also use that Texas version of the statute of frauds that he cited too.
Okay, thank you.
You're welcome. Or you can find your state's version of the statute of frauds by looking it up on Fastcase, or just go to Google. So let's go back to the assignment. So it's not very difficult. Use a standard memo heading. Find the recent case on the statute of frauds. IRAC that case. Issue, rule, analysis, conclusion. Use the Indigo Blue Book cite form for the case. 2. Find a recent article in the Rasmussen online library. For some reason it wasn't working, or I would have demonstrated that. 3. A legal blog on the internet that talks about the statute of frauds. Summarize it in a paragraph or less. 4. The statute of frauds that has been enacted in your home state. You can cite to that Texas one that was in that blog. Use the Indigo Blue Book for every source. Any questions about how to do that Module 3 memo? Great, we're right on target. So we're going to go back into the online classroom again for the Module 4 discussion forum. So this is another week in the course where you have a discussion forum. Using legal articles or blog posts, find an example of legal complexity that's hard to simplify. Be sure to cite to your reference and provide an example. Explain what makes the example complex and difficult to simplify. Here are a couple of exaggerated examples. In the event that the contingency of the failure to promptly fulfill the order for 1,000 widgets occurs, the buyer may, at the buyer's option, obtain cover, substitute goods from another supplier, or otherwise act so as to obtain the aforementioned goods that were not delivered. What's wrong with that, Nicole?
It doesn't make any sense. It sounds like they're saying that the seller has to fulfill the order in a timely manner, but they can substitute the goods from another supplier. And then if they don't deliver on them, then they can take other means to get them delivered.
Yeah, so that's an easier way to say it. So it's basically saying, in the event that the seller fails to fulfill the order of 1,000 widgets, which is any item, any goods. The buyer may obtain cover of substitute goods. Period. That's all you need to say.
Okay.
So that's a very wordy legalese. It's something that looks fancy that justifies attorneys charging $500 an hour to draft a contract. More and historically, that's the kind of language that they used in England. That's really where it came from. American legal traditions were brought over from England, and that's the kind of language that they used back in the 17th century in England. We can obviously simplify it. There is a trend towards simplifying it. Let's take a look at the next example of legalese. Whereas the buyer has failed to promptly notify the seller of the intention of the buyer to refuse either to pay the price or to explain failure to pay, and has failed to indicate non-acceptance of the goods, and the reason, therefore, for failure to so indicate, the seller shall refuse to stop deliveries and shall continue to invoice for them until further notice. What do you see that's wrong with that, Alyssa? The seller shall refuse to stop deliveries. Refuse to stop.
It's double negatives.
Bingo. Double negatives should always be avoided. Basically, they cancel each other out. It's like -1 and 1 equals 0. Minus A plus A equals 0. That pretty much means the seller can continue to ship and continue to invoice until the buyer gives notice to the seller and explain the reason for non-payment and explain the reason for rejection of the delivery. So that's basically what this is saying. If the buyer fails to promptly notify the seller of the buyer's intention to refuse to pay or to reject delivery of the goods, then the seller can continue to deliver and continue to invoice until they actually receive that notice. So that's an easier way of saying that, Alyssa, without the double negatives. So that's what we're doing in Module 4. You and your classmates are providing examples of legalese. And in order to get credit for this assignment, you need to go back, look at your classmates' example of legalese, and simplify it. Any questions?
None so far, but it's a good that I have the visual and the verbal of what you're explaining, so that if I do need to go back and listen, I'm okay.
Excellent. Yes, the live sessions are very helpful. Statistically, the students who attend the live session are the ones that get the highest grades because the learning is coming in many different ways. It's verbally, you're hearing it, it's visual, we're doing hands-on examples. The information is being provided in 5 or 6 different ways. So no matter what your learning style is, the live session is catering to that learning style. Simplifying legalese. So in your reply post in the discussion forum, simplify a classmate's example to make it more readable for your client. The problems are often too much repetition, too much complexity, double or triple negatives. Short sentences can help. And that's true when you're writing a memo, when you're summarizing a case, when you're writing a brief summary of a statute. Simplicity is appreciated. Double spacing is also appreciated so that the attorney can see what it is that you have typed. Like Alyssa said, remove double negatives and redundancy. Here's an example. Dale rejects, denies, and refuses to accept that the promise is contractual in nature. How would you make that simpler, Alyssa? Do you want to take a try at it, Nicole? How would you make that simpler?
Dale does not agree to accept that the promise is contractual in nature.
Yes. And that's okay, Alyssa, if your mic isn't working, I totally understand. Yes, Nicole. Rejects, denies, and refuses to accept is redundant. Dale rejects that the promise is contractual in nature, or more importantly, Dale denies that the promise is contractual in nature. That's good English, it's proper English, and it's simple. Let's take a look at the next example. At that point in time, whereupon and in the event that the goods are delivered, June shall pay the price. At that point in time, whereupon and in the event that the goods are delivered, June shall pay the price. How would you simplify that, Nicole?
Upon receipt of the goods, June will pay the price, shall pay the price.
Yep, I got an even easier way. When the goods are delivered, June will pay the price.
Okay.
Shall is also like Old English.
Right.
Shall has a command in it, so it's okay. It's okay. But when the goods are delivered, June shall pay the price. Can you think of a way to say it that's even simpler than that? I can't. June shall pay the price. No, I don't think that's anything simpler. All right. Let's take a review of the rules of grammar. In another class, I teach PhD students, and I also teach master's degree students, and some of them don't know the rules of grammar. So everybody can review the rules of grammar. It's a great idea to take the time out to review the rules of grammar. So sentence structure is something everyone needs to work on. A sentence has a subject that is the person taking the action, and a verb, which is the action that's being taken. Sometimes there is a linking verb, like number 2. I'm sorry, example 2. The subject and the verb must agree in terms of whether they are singular or plural. Tim and Bob is friends, or Tim and Bob are friends. Which one do you think is right, Nicole?
The second one, Bob and Tim are friends.
Why is that one correct?
I'm trying to remember how they explained it in English. Because it's two or more is plural. So that's why you have are.
You're correct. If it's singular, then is the linking verb. He is a friend is singular. He is a singular pronoun. Is a singular linking verb. Friend would be the object that the subject is referring to. Are is plural. They are friends, right? They is friends. They are friends is correct. They, plural, are plural. Okay, now let's take a look at the second example. Neither Bob nor Tim is going to the party. Neither Bob nor Tim are going to the party. Which one of those do you think is right, Nicole?
Again, it's a plural, so it would be neither Bob nor Tim are going to the party.
Neither
It's
nor.
the other one?
Neither nor, it's a trick. Neither nor is singular. Neither Bob nor Tim. He is not going to the party. So that's a trick question. That's a tricky one. Neither Bob nor Tim is actually singular.
Okay.
Neither nor. It's not plural because neither one of them is going to the party.
Well, I was looking at it in terms of, because it's two of them, like Bob and Tim are friends. That's why, in my mind, that was how I was reading, because it's two and not just singular, as you said before.
It's not two because neither one of them is going. Neither
Right.
nor. So that's a tricky one. All right, let's look at the third one. Shamika walked to school. Shamika walks to school. Which one of those is right, Nicole?
Shamika walks to school.
Yep. That's when you have a singular subject and you need to add an S to the verb. Now, if it was Shamika and Bonnie walk to school, they walk to school. So, these are some tricky rules of grammar. You can always go to the OWL, which is Purdue Writing Lab, Google it, and do the grammar exercises. If anyone is in question, like I said, when I'm teaching my graduate students and I look at their assignments and I see these errors, then I know if people who are getting their PhDs are making these errors, anybody could make these errors. And that second one is tricky. Who's ready for a quiz review? Hi, Isabel. Can you hear me? Isabel is back. Can you hear me, Isabel? Can you hear me, Alyssa? Isabel is gone again. Okay, Nicole. So here's our quiz review for the Module 4 quiz. Some familiar topics. It is a cumulative quiz. It covers everything from modules 1 through 4. 1. What are the 3 elements of a valid contract? Offer, acceptance, and consideration. 3. Do contracts have to be in writing? Do contracts have to be in writing? No. What laws apply to service contracts? Common law. What rules apply to contracts for the sale of goods over $500? The UCC, the Uniform Commercial Code. What is consideration? It's anything of legal value that is bargained for. It is the subject matter of the contract. Why should you put a contract in writing? It may help when you're enforcing it in a court of law. What is the statute of frauds? It is a special rule that says contracts for marriage, contracts that can't be performed within a year, guarantor contracts, co-signers, contracts for the sale of lands, contracts for the sale of goods over $500 must be in writing to be enforced in a court of law. The statute of frauds is a part of the UCC. What should a paralegal do if she finds an error in a contract? Point it out to his or her supervising attorney. IRAC is an acronym for what? For issue, rule, analysis, and conclusion. It is a way of analyzing and breaking down a case so that we can take a look at what the issue in the case is, what the rule is, analyze the facts and apply the rule and reach a conclusion. It's a way for us to find out if we need more information to reach that conclusion. Why do we use IRAC tables in Microsoft Word? To analyze a case, find out if we need more facts or if we need to do more research. What is the restatement second of contracts? It is a treatise. It is a secondary source of the law. Primary sources of the law are cases and statutes. Why do we use Lexis Advance or Fastcase? They're boutique, paid for legal research services with very reliable information. Under the UCC, what are the seller's duties? The seller's duty is to deliver the goods, tender delivery. Under the UCC, the buyer's duties are to accept delivery and pay. Okay. We have reached the end of the Module 4 live session. In order to get credit for this assignment, you need to submit the correct answer to the live session question after watching the live session video or attending the live session. Thank you, Alyssa, Nicole. So the question for Module 4, what are 3 remedies the buyer has under the Uniform Commercial Code in the event the seller breaches the contract? Please submit the correct answer by Sunday, July 31st. Any questions?
What was the last part that you just said? In the event that the buyer what?
If the seller breaches a contract, what can the buyer do as a legal remedy? What would you do? If you purchased a computer on the internet and it was never shipped by Best Buy, that's a contract governed by Uniform Commercial Code. What would you do as a buyer?
Try to I was enforce the contract of what I bought. First, I would try to
Okay.
negotiate it with the store, and if they aren't forthcoming or try to rectify the situation, then I would take it to a small claims court or thereabouts.
Okay, so the UCC has specific remedies that are available to the buyer. They are available in your book, and I also explained what they were last week in the Module 3 live session PowerPoint slide. The UCC itself provides 3 remedies for the buyer. You can Google this and type your answer into the live session Dropbox to get credit for this assignment.
Okay. Got it.
Great. Well, thank you so much, Alyssa and Nicole, for your excellent participation in the Module 4 live session. I look forward to receiving everyone's assignments on Sunday, July 31st. Next time I see you, we'll be in a whole new month called August.
All right. Thank you. Have a great night.
Okay, you too, Nicole. Have a great night. Bye, Alyssa.
Bye-bye.